Honourable Senators, this past weekend I celebrated National Indigenous Peoples Day by sundancing at the Alexander First Nation on Treaty 6 territory. It's a sacred ceremony that involves fasting, sacrifice, and deep prayers for the people, and it's something I've been doing since I was in my 20s. I'm grateful to Elders Fred and Melanie Campio for including me and my husband Alan in their ceremonial family, and for the kindness and humility they model for everyone who knows them. Towards the end of the last day of the ceremony, Member of Parliament Billy Moran, who was visiting the ceremony, and I were called to the tree in the center of the ceremony. Special prayers were made, and a song was sung for the work that we do here in Parliament. And actually, Senators, the elder there told me that they were singing for all of us, for the work that we are doing specifically here today. One of the elders, a man whose great-grandfather was a signatory of Treaty 6, then spoke to me in the middle of the ceremony about C-5. He expressed considerable misgivings about this legislation. He said he was afraid that the bill would be used to take yet more land from him and his people, and he wanted to come to Ottawa to tell us all about his connection to and deep knowledge of this land. As the ceremony ended Sunday night, I left thinking about what he said and the moment that Canada currently is in. Our need for energy security, the massive geopolitical change we are experiencing right now, in the context of a country that is still trying to repair internal nation-to-nation relationships after more than a century of injustice. I was thinking about the work that had been done in this chamber in recent years and decades, where we've come and where we still need to go. And I was thinking about a table. Now indulge me here, colleagues. The image in my mind as I left the Sundance and was driving home on Sunday night was a table in a field near Edmonton. Colleagues, join me in imagining this table as a representation of the legislative framework that protects the rights of First Nations, Métis, and Inuit people. The first leg of this table is Section 35 of the Constitution Act 1982, which says the existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. It defines Aboriginal people as First Nations, Inuit, and Métis, and it states that treaty rights, including existing or future land claim agreements. The language was approved by our predecessors in the Senate in December 1981 as part of a legislative process that unfolded on both sides of the Atlantic. The inclusion of Section 35 was a major step and critically important. Still, those few lines left so much to be clarified. Indigenous leaders have spent the last 3 decades clarifying them, largely by taking the government to court. It's been a long, expensive process, and there are far too many cases to cite individually. But now we do have a considerable body of jurisprudence about what Section 35 means. For example, in the Sparrow case in 1990, the Supreme Court established a set of criteria to determine whether an Indigenous right is infringed, and in what circumstances infringement can be justified. At the time, the court said one of the many factors to consider was whether Indigenous nation in question had been consulted or, quote, at the least informed, unquote. In 2004, the Haida Nation versus British Columbia, the court went further, finding that the government has a legal duty to consult when it, quote, contemplates conduct that might adversely affect an Indigenous right, unquote, and that good faith consultation may in turn lead to an obligation to accommodate Indigenous concerns. In the court's words, quote, what is required is a process of balancing interests, of give and take, unquote. And that's what we've seen in the years since. Progress has been imperfect and inconsistent, but overall there's no comparison to the way things worked before the duty to consult entered our lexicon. There's been an evolution in favor of dialogue, mitigation, and accommodation. It doesn't always lead to outcomes that everyone finds satisfying, but it's an evolution we can find encouraging. Of course, Section 35 doesn't solve anything. It's only one leg of the table. In 2018, the Mikisew Cree First Nation versus Canada, the Supreme Court found that the duty to consult does not apply to the legislative process. That decision left many Indigenous people deeply frustrated, and I totally understand that. Constitutional obligation or not, I certainly think it's a very good idea for the government to engage Indigenous peoples as early as possible in the legislative process. And I credit the last government for several legislative successes born of early consultation and even an attempt at co-development. These include the former Bill C-91 on Indigenous languages that my colleague Senator Francis was a sponsor of, and Bill C-92 on Indigenous Child and Family Services, which I had the honor to sponsor. And they include the second leg of the table that you're holding in your mind, the United Nations Declaration on the Rights of Indigenous Peoples, or the UNDRIP Act. This act requires the government to modernize federal laws to reflect UNDRIP's 46 articles and to create and implement an action plan that achieves UNDRIP's objective. That action plan was issued 2 years ago, and annual progress reports are published online for us all to see. Of particular relevance to our current debate, UNDRIP's Article 32 calls on states to obtain Indigenous peoples' free and informed consent prior to approving any project affecting Indigenous lands or resources. Accordingly, Canada's UNDRIP Action Plan commits the government to working with Indigenous peoples to develop guidelines for government and industry about how to obtain free, prior, and informed consent. So we have Section 35 of the Constitution, which, according to the Supreme Court, imposes on the government a duty to consult. That's leg number one. And we've got the UNDRIP Act, through which the Parliament has told government to go further, to adopt FPIC as leg number two. My table's third leg is one of the specific commitments made in the UNDRIP Action Plan that was accomplished, namely the addition of a non-derogation clause into the Interpretations Act. This was done through the former Bill S-13, which we studied in the Senate in 2023, and which was adopted by our colleagues in the other place last November. The Interpretations Act is a law that tells us how to interpret all other laws. The addition we made last year was something Indigenous people had been seeking for over a quarter of a century. This is the text we added. Every enactment is to be construed as upholding the Aboriginal Treaty Rights of Indigenous Peoples, recognized and affirmed by the Section 35 of the Constitution Act 1982, and not as abrogating or derogating from them. Previously, before S-13 was passed, some laws contained this kind of safeguard, but many didn't. And the exact wording varied from one law to another, creating potentially problematic inconsistencies in the way Indigenous rights were understood in different situations. The point of S-13 was to establish a single, uniform standard that would apply across the board, which is exactly what it did. It applies to every existing law, and it will apply to every new law that we study going forward, including, of course, Bill C-5. Before last November, we might have felt the need to add a non-derogation clause to this legislation to ensure that everyone understands that, as important as a project might be, there is no possibility of opting out of the Indigenous rights or taking shortcuts around them. And colleagues, people have tried to take shortcuts around our Section 35 rights. The non-derogation clause was a fail-safe. Now, though, with a non-derogation clause in the Interpretations Act, the centrality of Indigenous rights, as protected by Section 35 of the Charter, is an inherent feature of every law, including this one. At this point, and I thank you for holding that table in your head, we've got a table with three legs, all of which were built by Parliament. Legislators approved the language of Section 35. Legislators adopted the UNDRIP Act, and legislators put a non-derogation clause in the Interpretations Act. And Indigenous people fought for these changes for over 50 years. But the fourth and final leg, the one that gives the table stability and prevents it from falling over, is not one that we as legislators can build. In the Haydn Nation versus British Columbia case, the case I cited earlier, in which the Supreme Court found that the government had a legal duty to consult, the court also wrote this: in all its dealings with Aboriginal peoples, from the assertion of sovereignty to the resolution of claims and the implementation of treaties, the Crown must act honorably. And in the Mikisew Cree First Nations case, where the court found that the duty to consult does not apply to the legislative process, The majority found nonetheless that the honor of the Crown does apply. The honor of the Crown is an idea that goes back a long way. It's not something we can enact in law, but it's a crucial part of this process. We've actually got a colleague in our chamber who has written and spoke at length on this subject. And I'm going to base my description of it on a speech that Senator Arnott delivered in 1997, when he was obviously 12 years old, at the 6th Annual Powmaker Lecture. Long before we had a Charter of Rights and Freedoms, we adopted the British understanding of acting honorably for the sake of the sovereign. Throughout history, appealing to the honor of the Crown didn't mean, quote, simply appealing to the Crown as a person, but also to a bedrock of traditional principles of fundamental justice that lay beyond persons and politics, unquote. And it's from this understanding of the honor of the Crown that the Supreme Court has drawn the concept of the Crown's fiduciary duty in the context of fulfilling promises of treaties and upholding Indigenous rights. There's a story I want to tell you very quickly that Fred Campio told me, and it's about treaty signing. It's a simplistic interpretation, but I hope you can stay with me on it. When it came to treaty signing, the Crown entered the treaty negotiations and the process and the signing with a piece of paper, a written document that was a legal document based in the legal system of the Crown at the time. The Indigenous leaders came to treaty signing, and they wanted to have a pipe ceremony. Their idea was to bring the Creator into this relationship. They wanted to develop a wahkotoan, a sacred relationship with the people of this land so that going forward, they would be a part of nation building. That wahkotoan was the understanding that Indigenous leaders had of treaty signing. I would argue neither side understood what they were signing at the time. The government went away, and it took that treaty and it started passing laws that affected Indigenous people in traumatic and long-standing ways. Laws that caused the abduction of children from families, laws that caused economic devastation in communities. The government passed those laws while the Indigenous leaders still thought that they had a wahkotoan. And so when I hear leaders like Treaty 6 Grand Chief Greg Desjardins call Bill C-5, quote, a serious threat to our treaty rights, unquote, or when an elder tells me at ceremony that C-5 will take away his land, I hear them saying that they don't trust the Crown to act honorably. And who can blame them? We have over 150 years of dishonorable behavior. Even letters we've received that are cautiously optimistic about the bill, like those from Fort McKay First Nation and the Métis National Council, are full of reminders to the government to act honorably if and when C-5 passes. I understand the pain created by the Crown's historic dishonorable behavior, and frankly, I share a certain amount of skepticism about the honor of the Crown. But there's no amendment we can pass to change that. There's no bill we can adopt which will guarantee the honor of the Crown. Legislators have built three strong legs of this table: the Constitution, the UNDRIP Act, and the Interpretations Act. And by the way, that table I imagined when I was leaving Sundance isn't floating in midair. It's standing firmly on Treaty 6 land. The treaties provide the important foundation for the nation-to-nation relationship. Those treaties remind us that we have a wahkotoan, a sacred relationship that we can still reclaim. At a certain point, we've put in writing everything we can put in writing. And it's kind of a, if you can lead a horse to water situation. Or as my husband would say, you can lead a hippie to water, but you can't make him wash. We have done everything. We have led the horse to the water. We've enshrined First Nations, Métis, Inuit, and treaty rights in the Constitution. We've passed the UNDRIP Act, adding free, prior, and informed consent as one of the principles of consultation. We've amended the Interpretations Act. And this bill mentions all of those things. I don't think there's anything more we can do to the text of the bill to protect Indigenous rights. Senator Klein, we set the table. Now, at this pivotal and deeply uncertain moment for Canada, there's an opportunity for the government to achieve great things by acting honorably. And it's an opportunity for all of our leaders to come together, do the hard work of consultation and compromise, find common ground, and grow this country. The Prime Minister said He wants to put Indigenous partnerships at the center of this growth. He said that in a press conference. The Minister of Indigenous Services has spoken about the importance of relationship in the context of C-5. She says relationship...
Senator LaBoucane-Benson, I have to interrupt. Would you like to ask for more time?
Please.
Is leave granted?
Yes.
Thank you, colleagues. She says that the relationship will be, quote, a priority and a critical part of the work ahead, unquote. I agree about the importance of this relationship. The nation to relationship, our Wahkotuan, has always been about sharing the land for mutual benefit. But it hasn't always worked out that way. My plan is to support this bill, unamended, with all the legislative safeguards already in place, and then hold the government to its commitment to respect the relationship and behave with honor. And I will be holding the government from this position as legislative deputy to that honor. I understand the impulse to want to slow things down, but we really are at a moment of potential crisis. As the president of the Manitoba Métis Federation put it, we're facing the threat of economic war and the risk of Canada's economic engine to break apart, and in a way that will harm low-income and vulnerable Canadians the most. There will have to be consultation on projects. That's where the consultation has to happen, on each project, as they're proposed, because the law already demands it. But we need to move forward and begin consulting on the actual projects in the national interest. Again, thank you very much for indulging me on my table metaphor. And I hope my table is one where people will sit together, consult, negotiate, and listen to each other with humility and respect and build a better future. Thank you.